There we
There
go.
we go.
Okay, good.
Hey, good morning.
Good morning.
Good morning. All right. Well, Happy New Year, everyone. Thank you guys for joining us this morning. We have a really good episode this week. We have Tim Myers, who is our company attorney and legal counsel. So he's going to be talking about a lot of important things, some tips for agents regarding probate and wills and trusts and things that you guys should be aware of. But just to get started before we dive into the content, because there's going to be a lot, it might be helpful to take some notes if you would like. And obviously you can rewatch this on our YouTube channel in a couple days. Always be a resource for you, but definitely take some notes and buckle up because we got a lot of content. The first thing I want to just cover a few little housekeeping things. I don't want to take up too much time because Tim does have a lot of content. We might run over a little bit. So just to warn you guys, we could very well run over a few minutes, but I think it'll be worth your time. I know it'll be worth your time. I want to just let you guys know that we do have an upcoming photo program posted. So January 18th is part 1. Part 2 is February 15th. So I'll be running these. We do one like each quarter. So you guys are welcome to sign up for that. The part 1 class, we just kind of go over a little bit of everything, tips, techniques, different levels of equipment, some do's and don'ts. I'll have a sample listing, managing your photos. There's a lot of content in part 1, as well as homework that will be assigned. Then you can bring that homework to part 2, where we go through some of your struggles and some critiques and ways that you can improve, things that you did right. And it's going to be more meeting style. Both these classes are virtual right now. Hope to possibly get back into the field trips. Honestly, we don't know when with everything going on, but I'm hopeful sometime this year we'll be able to do the field trips where we go to a furnished modeled home and get to apply everything that you've learned in the first 2 classes. So if you're interested in signing up for these classes, you want to have a DSLR camera or one of the new Pro smartphones, or the iPhone Pro Max has a lot of the features that are great for real estate photography. So we cover those. You're obviously welcome to sign up for part 1, but to apply the stuff that you learn, you're going to want to use one of those cameras to do your homework.
And I have to tell you, I actually took Taylor's class back when we were doing the photo field trip, and I learned so much. So I am so grateful. It seems like every time you take a picture of a bridgeway or a hallway, it always looks short and dumpy. And Taylor showed me how to add, more aperture and more light to the shot so you can elongate it and show how long those hallways are. And we've all got those little powder rooms where we try to take the picture and you see the toilet front and center, like you didn't know it had a toilet, right? And she shows you how to do her patented shot where you can angle up into the mirror off the counter and just made a world of difference. So I totally recommend taking that class, but I know size is limited too. So you want to get signed up.
Yeah. Part 1, we can take a lot of people in part 1. Part 2, if there's a ton of demand for it, we might break up a couple different classes so that everybody gets a little bit more time with their critiques and stuff like that. But so far it's been so good. We haven't had to do multiple part 2s or anything yet. So go ahead and sign up for those if that's something you're interested in. It's winter. It's a great time to start taking classes and get ready for the busy season approaching. I'm going to put those links to register in the chat for you guys as well. And one last thing before we dive in is subscribing to our YouTube channel. Colleen, do you want to talk about the promo that we're going to do?
Absolutely. So it's exciting. Last year, we set a goal of having 1,000 subscribers on our YouTube channel. We are just about 25 people short of that. So we decided to do a little contest today. What we're going to do is we've got about 60 people on right now. If we reach our goal while we're on our show, everyone attending is going to get some MiRealSource swag. I was going to grab one of the cool canteen water bottles that you just got us. So what we're going to do is if we reach our goal, which is 1,000 subscribers, which is like 25 people away, we're going to do a giveaway for a gift card. All right. Well, I am excited about talking to Tim. I recently had a transaction where I had someone pass away in the middle of a transaction. There was so much I didn't know. And Tim, I always love talking to him. I learn so much from him, just even our quick conversations. I'm always got a great takeaway. So I'm excited to hear what you have to say today.
Thank you. I appreciate that. No pressure there. Huh?
Yeah. Well, let me pull up the PowerPoint slide. So we got that right here. All right. Can you guys see that okay?
So when Colleen first reached out to me and said, hey, is there something that you can come in and talk to our group about? I said, well, what are some of the hot topics? What are some of the things that cause some angst, some trouble, some concern, chewing on fingers, etc. And she said, well, probate, we don't like probate when it comes to the probate or when it comes to real property transactions. And I said, we can certainly put something like that together. And how I've approached this, because probate itself is a 900-pound gorilla in any room, and we could go on for 14 days straight and just barely scratch the surface of what probate really is. So the approach that I thought we would take is to kind of just give some agent tips to approach it more or less from the agent's angle, and let you know these are some things to look out for. These are some things to watch for. And we've got probably an entire spectrum of experience here, folks that are very experienced handling transactions within the probate world, and then some who probably are on the other end of that spectrum. And this is hopefully designed to kind of touch on everybody's experience level. So the overview of the presentation here, I guess, is what is probate? What is it not? When can you sell land? And what happens from the agent's perspective if probate is necessary? So let's start really with the big question: what is probate? It's the legal process of transferring ownership of a decedent's property to beneficiaries. And there's probably a little bit in there to unpack. To that end, I thought we would maybe start with some definitions of what some of these things are. So let's talk about definitions. So what is a decedent? When a person dies, that person is called a decedent. Pretty straightforward there. And so what is a decedent's estate? The decedent's estate is the property that the decedent leaves behind that has to be passed to those who inherit it. And those people are called the heirs. And the heirs are the folks that we leave the property directly to. It can also be if we don't have a will, for example. The state of Michigan has provided a statutory scheme that identifies who would inherit our stuff. What is a will? A will is a legally binding document that directs how the decedent's property is to be distributed. A common mistake that people make is, well, I have a will, so I avoid probate, right? The will itself is an expression. Think of it in terms of it's an expression of your wishes from beyond. And it's a legally enforceable document, but that's kind of where it ends. Many times people think, well, my property's in the will, or my dad or mom's property, they own it, but their will says that when they die, I get it. So we don't have to worry about anything, right? And the answer to that, surprisingly to many people, is no. The will does not transfer property itself. That only comes through a deed or court order. But when somebody might reach out to you, a potential client that says, well, mom passed away and she left everything to us kids, and we're ready to sell it. And many times those people say, she had a will, so we're okay, go ahead and list it. That's not really the inquiry at that point. That's probably the starting point for potential issues from the agent standpoint. Another thing that people often ask about is, what is a trust? A trust, much like a will, is a legal document that outlines how your property is to be distributed. It's generally much more complex than a will. And again, we can go on for days about just what is a trust. There are many different types of them. The most common is what's called a revocable trust, and many times people refer to those as living trusts. Unlike a will, it usually allows property to pass outside of the probate process, assuming certain conditions are met. But it's a much more complicated document than a will, albeit a document that does state these are what my wishes are once I've left this world. What is estate planning? That's another big question that I often get asked. And estate plan is one or more documents that determine how your stuff, your assets, are going to be disposed of after you've left us. And when properly done, and I want to underscore properly, there are many improperly done estate plans out there, but when properly done, it allows a seamless transition of ownership and allows us to avoid probate. When is probate required? Probate's needed when the assets are titled solely in the decedent's name. Really what we want is a succession plan, a legal succession plan, so that there's a connection, something that passes out, again, outside of the probate process to our beneficiary, who the person is that we want to receive our stuff. Now that we know when probate may be required, when is probate not required? Probate's not required when the decedent's asset is owned jointly with another person, or there's some sort of transfer on death or a payable on death designation. By law, title to the asset has to automatically pass to this joint owner at the time that the decedent leaves us. And again, what we're looking for is that seamless transaction so that we don't have to take action to transfer the ownership interest.
So is that joint ownership of the deed and of the estate or the deed?
Sure. Let's just starting with the deed. It can be a property that's owned joint tenants with full rights of survivorship by the entireties, which is also known as husband and wife. It's also another way to think of it is your bank account, your checking account. If the checking account is solely in your name, there is no seamless transition once you pass. That's something where somebody is going to have to come in and take action. If we own our checking account, or if we have a joint owner on the account with us, legally that money is both parties, and when one leaves us, it passes automatically by operation of law outside of probate to the other designated person. Insurance policies are another way to look at things where we have designated beneficiaries. We can do that with our checking accounts, with our savings accounts. We can designate a person, a beneficiary, to take our money. Many banks call these transfer on death or payable on death, TODs or PODs. But much like insurance policy, we're designating somebody that's going to receive our stuff. There is a seamless transition at that point so that the asset passes automatically upon our death to whoever our beneficiary is. So in that situation, probate would not be required.
Okay.
And so when the asset is jointly owned, we say it passes outside of probate. And here are some of the examples. Taylor was anticipating this one: jointly owned land or property in a trust, jointly owned bank accounts or other financial accounts, life insurance policies, something where we've attached somebody else's name to our stuff, and it's going to go to them by operation of law.
This might be a silly question. Husband and wife, they don't have a trust set up. They have children. Can you list a beneficiary of your children with your deed or your estate, or is that all in a trust? Okay, so the trust, it's a big monster of a document. Potentially it's out there. A trust allows us to designate beneficiaries so that once we pass, then we have, think of it as a playbook. That it's not necessarily for us while we're alive. And I'm talking right now about a revocable trust. A revocable trust, Taylor, for example, you've got small children. You and your husband would set up possibly a trust
a revocable trust, as long as you're alive, you get to do anything you want with that trust. And it's only if something were to happen to you. And when we estate plan, we generally estate plan for the worst case scenario, the catastrophic injury. You and your family are out to dinner, and the delivery truck plows through a red light, takes your car out, and you and your husband leave us. Now we've got these small children. A trust is a very valuable tool for setting up a successor to come in that's going to maybe not raise your kids, but be financially responsible to take your assets, turn those into money or investments or something to then raise your children. And what a trust would allow in the form of a playbook, a successor to do is to come in and say, okay, for my children, and if they're small, we don't know what they're going to be like when they're 10, when they're 15, when they're 18, when they're 21, when they're 25. And a trust allows a lot of flexibility. We can potentially micromanage from the grave and say, well, at 7 years old, my kid is going to take a trip to the Grand Canyon. And at 12, my kid is going to go see plays on Broadway. And at 15, we're going to do a stadium tour of all the baseball fields in the country. And that's a way for you to say, this is what I want my child to experience. Now, the problem with that is when you micromanage from the grave, your child might not have any interest in these things that you've predetermined that they're going to go out and do. But the other end of that spectrum is how much discretion or authority do you want to grant your successor to use this money to pay to raise your children? And many times, at what point do we want to turn over money to them? So if your kids were older, say 17 or 18, and you leave us, there might be a sizable chunk of money there. Do we want to give it to them all at 21? Do we want to stagger this so that there's a distribution at 25, at 28, at 32 to maybe let them have some money in their youth, make some mistakes, but then have that safety?
So you cannot put a beneficiary on your deed or your estate, but it would have to be in a trust listed, what your wishes are with that property.
We certainly can. There's a lot of tools in our toolkit for estate planning. And one of the ways that we can, for example, speaking of real property, and we see these, they're becoming much more popular these days, is what's called a ladybird deed. And a ladybird deed allows us to keep possession of the property for our lives. And then at our death, if we own that property, we've designated who will take this. And that is going to be a seamless transition outside of the probate process.
Yep. Okay.
So why might we want to avoid probate? We should have the right to decide who gets our stuff once we're no longer alive, our assets. We've worked hard to gather our stuff, and we should be the ones that decide. And sometimes, even more importantly, we want to be able to decide who's not going to get our stuff. It's, if we're unmarried, maybe it's a sibling that we've not gotten along with, or if we're a parent, the child who moved to New Mexico when they were 17 and hasn't spoken to us in the last 35 years, maybe we say, you're not getting my stuff that I've worked my life for. This is going to go to these other folks. Or maybe we have children that have left us and we've got a niece or nephew that is still around. We want our stuff to go to them. So probate, if we haven't properly estate planned, probate is going to tell us that the government has set forth a statutory scheme called intestate succession. And what that means is if we don't say who gets our stuff, the government tells us who gets our stuff. And the other big thing is probate costs money. And you're more than likely paying an attorney to come in, handle the probate process. The court charges fees. They take 3 big bites of your money away from you that could and should be going to your people, your heirs, the people that you want the money to. So rather than lining somebody else's pocket with your money, just keep it in the family. Let's let it go to somebody else that you want it to. Plus, the probate process at a minimum is 5 to 6 months. And it goes up from there.
One question real quick. I know we're not taking a ton of questions because a lot of the stuff will be covered, but Sarah asked, is a ladybird deed, AKA a life lease for a property?
It's essentially that. With the ladybird deed, the grantor they're deeding themselves what's called a life estate. And what that means is during your life, you get to do anything you want with the property. You can rent it, you can sell it, you can burn it down, and your designated beneficiary doesn't have any right to that property. They have a contingent interest in the property. They don't have any right to come in and tell you, this is what I want you to do. Stop cutting that lumber. Don't tear that pole barn down. And if you do sell it, then the contingent beneficiaries, they just go away. They don't get anything. But during your life, it's entirely yours and you have complete say over it. The Ladybird deed only becomes effective for the beneficiaries if and when you pass and you still own the property at that time.
Okay. So
let's jump into a scenario here from the agent's standpoint. You get that call, the call. Somebody has died and one of the decedent's family member wants you to sell the real property for them. What should you do? So let's start with an agent tip here. The first thing that you should be thinking of when you get a phone call when somebody says, my mom's passed away, my brother's passed away, my dad passed away, and we want to sell this land, is who are you speaking to? Who's on the other end of the phone that's calling you up and asking you to sell this? Certainly you're happy. You love that call. I'm here to sell your property for you and get you the best price we can. But does this person have the right to sell the property? The first tip that you should be asking is who is on the other end of the line? So with any real estate transaction, those parties that hold an interest in the property have to agree. They have to agree to everything. They have to agree to sell. They have to sign the listing agreement. They have to accept the offer, and then they have to participate in the closing. And obviously, if an owner has passed away, we suddenly have a blank space on the listing agreement, on that purchase agreement, and then at the closing. So let's figure out, what are we going to do to fill in that blank? Be sure the person you're working with is the proper person. Otherwise, that listing agreement is completely and totally meaningless. Start with how the property is titled. The pre-commitment is the best way to begin. Title professional can help you here, but we need to know who is entitled, because as many of you know, when you receive that phone call, it's not always a reliable source on the other end as far as, oh, I own the property. I own the property with this person. And once that pre-title comes back, suddenly it's a whole new ballgame for you. So our ownership options when pre-title comes back, maybe it's in the decedent's name only. Dad owned the property, he's passed away, and he didn't do any estate planning, or what he didn't properly address the real property. Maybe it's held by husband and wife. Maybe it's joint tenants with full rights of survivorship. Maybe it's tenants in common. That could be a bigger issue. Here's our Ladybird deed. Maybe it's in a trust. Maybe it's what we call a deed in the drawer. Those are always dangerous, and title companies, they cringe if you ever mention deed in the drawer to somebody. A deed in the drawer is something that's been executed. I'm leaving my property to my brother, and then I die, and instead of recording it, instead of giving it to him, I go ahead and stick that in the drawer, so that when I die, somebody pulls it out and says, oh, well, the brother owns the property. So, but how are we, how property is titled is going to be really the biggest thing that is going to direct us onto the next phase here.
So does a trust will always trump the deed in the drawer, correct?
Maybe. There's a lot of maybes. It's the lawyer's favorite answer and the client's least favorite answer. It depends. And typically with a trust, and for those of you out there who have a trust, make sure that your trust has been funded. And what that means is that there's assets in the trust name. Most commonly, we deed our property into the trust or to the trustee on behalf of the trust. Many estate planning attorneys don't take that extra step. There's not often a lot of crossover between attorneys that practice real estate law and attorneys that practice estate planning and probate. Okay. And estate planning attorneys oftentimes view a deed as somebody else's responsibility, real estate attorney's responsibility. And it's not uncommon for me to receive a phone call. Well, my property's in the trust and we're looking to update our trust. Are you sure the property's in the trust? Oh yeah, the attorney, when we walked out, the attorney told us we were all set. At the end of this massive binder that's titled trust, the very last page of oftentimes 300 pages in this binder is a page that says it's the client's responsibility to make sure that the property is deeded into the trust. Merely setting up a trust and saying this property should be distributed this way isn't enough. Again, as I mentioned earlier, only a deed or a court order is going to transfer real property.
Okay.
As a general rule, and to do a little bit of a recap here, property passes outside of probate when held by husband and wife, joint tenants with full rights of survivorship, in a trust, or by a ladybird deed. So if pre-title comes back and we're showing that the decedent held title in one of these ways, dad died, but mom is still alive, mom owns title. We don't have to go through the probate process for dad. If it's a joint tenant with full right of survivorship and we still have one of those survivors, it's going to pass outside of probate. You're okay to move forward to the listing. If it's in a trust and pre-title shows that it's titled, that the property is titled in the name of the trust, then you're okay. If it's a ladybird deed, again, you're okay. A property may need to go through the probate process, though, if it was held solely by the decedent as a tenant in common. If it's husband and wife and dad just passed, but mom passed a year or so earlier and there was no changes done to title, you're probably going through the probate process here. So opening probate, let me just talk for a second about what that process entails. If that needs to be if we do need to go through probate, if it's a scenario where mom predeceased dad and you've received that phone call, a decedent's estate does need to be open with the probate court. We file a number of documents as part of the probate opening process, and we have a person appointed that's called a personal representative. The personal representative is the one who's charged with the administrative management of the decedent's estate. And there's a number of things that go into that. It's not a responsibility that is to be taken lightly. Most often, the attorney is going to be the one that handles most of the water carrying, preparing the documents, calendaring and tracking, and communicating with the personal representative as far as what steps are needed. Not always, but oftentimes that is the attorney's role to take the lead on that. The probate court issues to the personal representative what's called a letter of authority. And the letter of authority is the legal right, the formal authorization from the court for the personal rep, for the PR to move forward. And something like this, it would allow the PR to go into a bank and close out the decedent's bank account. It allows the PR to sign a listing agreement, to accept an offer, and to sign the closing documents at the purchase table.
How do they usually determine who that person is?
It's generally one of the things that's identified in a will, if the decedent had a will. If not, the family many times can come to an agreement. Oftentimes they'll come in. I'll have 4 or 5 siblings come in and sit in my office, and it'll be the oldest one, or it'll be the youngest one, or it'll be the bossiest one that's gonna take charge, and we're gonna take care of this. And the other one say, "Good, you go do that work." Yeah. So, and if not, the state of Michigan has given us a statutory scheme that says these are the people that are entitled to be the PR.
And they have to agree and decide who the person is.
Well, it's not a forced job. It's something that we want volunteers, not hostages, because it is a job. Sometimes it's much more complicated and onerous than other times. Other times it's come on in and sign some documents and I'll take care of the process from there.
Yeah. Okay.
Gotcha.
So when you receive the call, sometimes it's made clear that the property is going to be going through probate. We're working with an attorney. We're ready to sell. your client needs to be the personal representative. That person doesn't need to be the only client. Sometimes we're dealing, especially if it's a joint tenant with full rights of survivorship, or a tenant in common, maybe, where mom passed away and a son was in title as a tenant in common with her. The personal representative needs to be your client along with the other people who have an interest in that property, so that we have full cooperation. They're the ones that need to come in and sign the listing agreement and all the other documents. But do yourself a favor. Somebody says, I'm the personal representative of so-and-so's estate. Ask them to see their letter of authority. There's no sense on their part to hide any of this. They need to be sharing this with everybody that they come across in a business dealing anyway. But that letter of authority is going to prove to you as the agent, yep, I'm dealing with the proper person.
And who actually issues that letter?
The letter comes from the court, from the probate court.
Okay.
And that's part of the estate opening process. Some of the probate courts are open, some by appointment. Over the last year, it's been a bit challenging. I used to say in olden times, known as before April of 2020, we could just walk in, get it from the probate court counter. That's starting to come back a little bit more, but it comes from the court. A few words about letters of authority here. Sometimes the court will restrict or limit the personal representative's ability to sell real estate. And if a restriction is included in that letter, it's going to be on the face of the letter. There's a box. A letter of authority is a one-page document that gives the authority to act. It identifies who the PR is. If there is a restriction, there's a box there that will say no real property can be sold without court approval, or no real property shall be sold for 90 days. That's the second reason why you want to look at or to request your client's letter of authority, not only to verify, yes, I am really dealing with the person who has the authority here, but also to make sure there's nothing out there that's going to stop this sale. And there's nothing that's going to throw cold water on everybody's face more than thinking, oh, we've got a letter of authority and probate's been opened, and then find out that the letter of authority does state court approval required. So other times it's not clear if the property needs to go through the probate process. Sometimes the caller just doesn't know. Sometimes mom died. I don't know what the process is. Can you help me? This is going to require you to put on your detective's hat. Some of the questions that you want to have running through your mind when you're trying to unwind a scenario, especially when that call comes in that, I don't know, do we need probate? Do we not need probate? Somebody's passed away, they own property. We know we want to sell it. We know we want to hire you to sell it. Help me out here. So was the decedent married? Are you working with the spouse? If not, why not? Is it one of the decedent's children? Are there other children? Are they in agreements? It's not uncommon to get that phone call where one says, we're going to sell the property. I want to sell it right now because I want to take a cruise. I'm looking to buy some investment property. I've got some bills to pay off. Let's get this sold right away. And then maybe the other children say, no, let's cool your jets for a second. We need to do some improvements there. The house is dated. Maybe one of us is going to buy it. And so you need some consensus before you just jump in and say, all right, we're off to the races.
Is a letter of authority really only in the probate process, not in the trust process? Like if a trust is created and a person's named, then they handle that.
That's correct.
Okay.
A trust is going to be the reason for us having a property in the trust is to avoid the whole probate process in its entirety. Okay. And so the letter of authority is just dealing with, at least in the decedent's estate context, it's going to be just for the probate process and what the personal representative can and can't do.
Okay.
So, sorry about that.
Nope.
Another question that should be running through your mind as an agent is, what type of property is this? Is it a primary residence? Was it an investment property? Is it a rental? Is it being sold on land contract? These are going to tell you, are there other issues? Are there other people that have interests in this? that's going to potentially complicate the transaction. Is the property occupied? By whom? Again, is it a renter that's in there? Is it a brother? Is it a cousin? Are we going to have issues getting this person out? And are there creditor issues that might delay the sale? So these are all things that you might want to have in the back of your mind when you're getting these phone calls.
So if an investment property has a tenant in there and the owner passes away, is that automatically part of the trust and the tenant has to evacuate, or is that something usually in the rental agreements?
That's gonna be first of all determined by what the lease agreement says.
Okay.
And secondly, if the person is in there and there is a right to sell the property, sometimes that renter does have the right to stay in the property, and whoever buys the property is then going to take the property subject to the renter. If there is a right to evict that property, then hopefully you can reach some sort of a common ground with the tenant to have them voluntarily vacate. And if that's going to happen, I would recommend holding off on listing the property, especially with the climate right now where properties are selling like that. Get the person out, because if they're not willing to voluntarily vacate, then you may be looking at an eviction proceeding. And because it's a court proceeding, sometimes those take a little bit longer than what everybody expects.
Mm-hmm.
So the answers to these questions when you're wearing your detective's hats is, can it be sold now? Are we going to have to deal with some other issues that we need to put? Maybe you can sign the listing agreement right now, get that client on board with you for the next 6 months, 12 months, however long the listing agreement's going to be. And then you have a little bit of a security blanket to say, okay, we're not necessarily rushed here. But is there going to be something else that needs to take place, either probate or some of these other items, before we can actually put the property into the MLS and start moving forward?
So to piggyback off one question regarding putting the property in the MLS, there's a question about when you list a home and it needs court approval, does that court decide what the bottom line price of the home is going to be, or is that still put on the appraiser and the agent?
It depends. It depends on what the specific circumstances are. To provide some context, if it's just a straight limitation, we want to make sure that the heirs and the interested parties, the beneficiaries, are protected by this. Then it's just a matter of going in and saying, Judge, we want to sell this property. Okay. Other times, if it's a contested situation where it's already, we want to put it on the market and somebody says, well, we want to sell it for $100,000. And some other folks are saying this property is worth $250,000. Now we've got a potential dispute that we probably want a probate judge to get involved with for the protection of everybody, for the protection of the agent, for the protection of the personal representative, for the protection of the beneficiaries, the interested parties, the heirs, so that an independent authority comes in, takes in consideration. This is what your argument is. This is what your argument is. Okay, I am going to tell you the property must be listed for a minimum amount of this. So the answer is, it all depends on what the context is, the factual scenario that we're dealing with at that particular time.
And then do these courts work with a special designated realtor, or do they just determine that if that's the case?
Not usually. Usually the personal representative is going to be the one that's going to have that authority to do that. Again, I've been involved with scenarios where the court has stepped in and said, and this person over here is going to be the agent. Usually that's a kind of a complicated outlier where that's what's in the best interest of the estate. And by that point, there have been hearings, there have been documents filed with the court as far as why it should be this way, why it should be that way. If the parties are generally in agreement, then the court's going to allow the parties to handle their business themselves.
Okay.
So if you are asked by a client to review a will or a trust to help figure things out, because that's something that many times clients are looking to you as the as the professional, help me out here. The best thing you can do on this is to punt that football down the field. Leave the review of these documents to an experienced probate attorney. You're wading into water that you don't want to be in. And there's a couple of reasons for that, notwithstanding however helpful you might want to be. One of the first reasons is that it might be considered the unauthorized practice of law if you start interpreting and rendering opinions about, I think your will says this, I think your trust says that, I think you can do this. And if we go to the next slide, I think I've got some things here. The will or trust can change when and how the property can be listed. Sometimes these documents they include conflicting directives. The will might say one thing, the trust might say something else. And even within each document, there may be things that make you go, what? I don't understand what was being said here. The experienced probate attorney, that's what their job is. That's the waters that they swim in. And they're the ones with the malpractice insurance in the event that things go off the rails for them. And one of the other reasons is if you're wrong, you've got an angry client, and maybe the client's brothers and sisters or family members are pretty angry with you too. And you don't want somebody going on Facebook and saying this agent doesn't know what they're doing because you were just trying to be helpful.
Stay in your lane. Is that what you're saying, Tim?
I was not going to use that phrase.
Stick with what you do, and you know. And
so
lose a listing or get legal trouble for it.
Right. And many times it's a good faith effort. We want to help. We want to, let me help you out here. You're really struggling on this, and I can read. It may end up being more of a headache and a hassle to you than it's worth. So our next scenario here is here comes the call. Your client's father passed away. He had an estate plan. He had everything taken care of except for 1 acre up north, and it's only worth about $7,000. And the family says, we sell it. It's not even worth our time here. So what do we do with this? Under this scenario, the state of Michigan, to their credit, our legislators have provided us with what's called the small estate procedure. And this is entitled to save some money and to expedite the process. When you look at it reasonably, you say, well, wait a minute, we've got this one item that's out there. It's worth a small amount of money. We can end up paying more to an attorney and to the court than this property is going to be worth. I mean, why do that? What we would do in this scenario is submit to the court what's called a petition in order for assignment. And we include the death certificate and a filing fee. And that petition asks the court to assign this property. Again, the way that we transfer real property, either by deed or by court order. And here, the court order is usually going to the heir, to a surviving spouse, to a sibling of the decedent, or to the decedent's children. And the court signs this order identifying XYZ is now the owner of the property. We certify this with the county clerk's office, and then we record it with the Register of Deeds. Once it's been recorded, that property is now marketable, and you can list it. Here's our big one, our doozy, our scenario number 3. The call comes in. So your client calls up, and her dear old Aunt Mary has passed away. You know them, you know the family. It's a disaster. They've always been a disaster, except for your client. They're a wreck. It's a train wreck. Every time you see her, she's telling you more and more stories that make you go. So Aunt Mary's children have been located out of state, and they don't come back to consider anymore. So your client has taken on the responsibility of caring for Mary during her final years. And she calls you up and she says, Aunt Mary left everything to me. And you say, congratulations, because you know Aunt Mary, she was loaded. And you put the request in for pre-title, and it comes back that her 40-acre lakefront parcel with somebody standing in the wings with a cash offer that's 30,000 above list price is ready to go. And you're thinking, yes, all right. But then pre-title tells you, well, wait a minute. It was just in Mary's name and we're going through probate on this. So you think, okay, all right, we're still right there on the cusp. And then your client calls up a couple of days later and says, well, I've talked to my cousins and they've seen the will and they are not happy. Nobody's happy. They want theirs and they really want the proceeds from this house. But she left it to me. It's mine. It's supposed to be mine. You're going through the probate process, and then your client says, my cousins have a lawyer lined up, and they are willing to fight because there's a lot of money involved. So what do we do?
This is the stuff movies are made of.
Yeah. Well, it's things that regular everyday transactions are made of. So, and next screen. Can you still list the property? Given the facts here, you can sign that listing agreement. Again, your client needs, assuming that the will has identified her as the personal representative, what has to happen here is she needs to be appointed personal representative, have that letter of authority issued so you can sign the listing agreement. But at that point, you need to cool your jets. You need to sit back and wait for the court process to work itself out. There are going to be hearings. There's going to be money spent. This battle is going to go on. It may not just be in the probate court. It may go up on appeal. It may come back down. This is something that could go on months and months and possibly even years, depending on how much money is involved and depending on how much money each side has. So my recommendation on this is go up to the starting line, get the client to sign off on the listing agreement, and then put this one on the back burner. Unfortunately.
Cool your jets.
Cool your jets. Not easy, especially when you're looking at what that facts scenario is.
Yeah. So if everything was given to the niece or nephew and they have several kids out of state, everything's listed to this niece or nephew, will, trust, everything, power of attorney, all that. And do these siblings or these three children have any kind of ground? I mean, you can sue for anything, but do they really have any kind of grounds at that point?
Well, I'm gonna hit you with this, answer that everybody hates. It all depends. That scenario really comes down to the very specific factual detail. When there is a challenge to a will, and in that scenario, Aunt Mary, it seems, had done a lot, but she hadn't changed title to the property. A ladybird deed would have been the perfect vehicle to avoid all of these problems, although even ladybird deeds can be challenged, much like that will was going to be challenged. There's fraud claims, there's undue influence claims, there's a number of challenges, the competency claims that Mary's children can potentially raise to have that will set aside. And if there's no will, then the state of Michigan's intestate succession says that all that property is going to go to the children and the niece is going to be cut out of it. So that's a potentially devastating scenario for the client there, for the niece, if the court makes a determination. And again, we're looking at probably multiple hearings and a lot of work going in on both sides to get to the point where the court is going to make a decision on whether or not this is the will is going to stand or the will is going to be vacated.
Okay.
Our closing agent tip on this one, the probate process, like some of your other favorite items out there, tax and judgment liens, divorce judgments, bankruptcies, they create complicating factors for your transaction. Don't be afraid of these things. Approach it with caution, your eyes wide open. Again, your detective hat early on is going to do you some favors. It's going to help you out if you can kind of identify before you get too far into this. Many agents like to rush. We got to get this thing listed. We got to get on the MLS. Well, we got an offer in. Let's move it. Sometimes when these red flags are starting to come in, we need to back down a little bit. Each one of these areas, the liens, the divorces, the bankruptcies, they're a very specialized area of the law. Protect yourself, protect your broker. Your broker would appreciate this. Protect your client. Send your client to an experienced attorney in that particular area. Have that attorney assist you. There's no reason why there can't be a relationship where the attorney and the agent work together. I prefer that. Let me do my stuff so that I can let you do your stuff. Ultimately, our goal should be the same, and that is to get to the closing table. We want our client to be able to sell this property if that's what they want. And as the agents, let the attorney assist you with this process. Don't try to be too helpful. Don't try to jump into something that might be a little bit too complicated and make people angry if you're wrong on this. Send them out to an attorney who's experienced in that area and can provide the legal guidance that everybody needs.
Okay. Colleen, is there anything you want to add before we close?
I made tons of notes, Tim, so I can't thank you enough. I've learned a whole lot. I got to tell you, it's so complicated, but I think the big takeaway is definitely stay in your lane. Definitely, don't play attorney. I know a great attorney that would be very helpful in this scenario.
There he is.
There he is.
Me. Okay, thank you. I appreciate that. So, and I see that we made it in. My talking allowed us to within the 1 hour. So
yeah. I know there was one question that I thought was kind of interesting just to check.
While you're looking that up, Tim, just so you know, we're getting a lot of great infos. Thank you. This has been so helpful. So a lot of great feedback coming in.
Well, thank you for having me. I enjoy this opportunity, and it's when there's informed agents that makes my job easier. If and when a situation does arise where you need help or your client needs help, as opposed to the scenarios where somebody has led somebody down a path and the client is now angry, or a family member's client is angry and something like that. We have to undo something that.
And as a co-oping agent on the other end, I think we all thank you for giving all this great information, because there's nothing worse than, you're right, being a co-oping agent and finding out they didn't even know who they were really dealing with. So that is great advice.
Yeah, this one's kind of interesting. Just the owner passed and they had only a will. The executor has told me that there's a lawsuit came payable after death of $10,000. Does this become included, or is this something that has to be filed, document signed, or split and divided between the parties?
It depends. I would need a little bit more information to give you an answer on something like that. It sounds like it is a mess, and unfortunately, it causes me. I've got a lot of questions about what the $10,000 judgment
lawsuit. Yeah. Yeah.
Just
a lawsuit hanging out there.
Yeah. Hey, you never know what's coming at you.
Yeah. Yeah. Everybody's saying thank you. Very helpful. This was great, Tim. Thank you very much. I learned a lot.
Good.
Going through this.
That's better. That's better than the alternative.
Yeah.
You didn't get anything out of it.
It is really, really good. So, and then Taylor put up Tim's information. Should you have any questions or looking for a great attorney who I can't say enough great things about, that's your guy.
Thank you. Appreciate that.
Well, thank you very much, Tim. I appreciate it. We're 11 away. So if you already subscribed, we'll be considering that. Subscribe today. Great. Thank you. You'll be getting some swag sent to you, as well as part of the drawing for the Amazon gift card. And please share this video when we post it on our YouTube channel, our Facebook. Go ahead and let people know to subscribe to us. Help us meet our goal going into 2022. That would be wonderful.
We are almost there, so it's exciting.
Next
thank you
month,
again.
Yeah, thank you so much, Tim.
All right.
What are we subscribing to? Jared, our YouTube channel, MiRealSource Media. If you subscribe, then you will be part of our giveaway. When you go to our YouTube channel, MiRealSource Media, there'll be a red subscribe button. You can just click on that. we get notifications, emails of everybody who came in today, as well as Colleen has been taking notes throughout this of everybody that has subscribed to get out some swag to you guys. And join us next month. We are going to have a new product that we're going to be launching. The representative from the company, marketing representative from the company, is going to be talking about this product. We're really excited about it. So you guys stay tuned. You'll be hearing about it soon. And he's going to kind of be giving you some tips on managing rental properties, the tools that are available to you, and things like that. So it'll be a good one as well.
One more quick question. We did have a couple of people who joined late and said, where do they subscribe? Taylor put the link in there. I put also a link in there to the direct subscribe. So as soon as you click on it, we'll ask you, would you like to subscribe first? So if you joined us late and you're looking for that subscribe link, I just posted it in the chat. Just click on it. It'll take you right there.
And I am just posting the URLs to the photo program. I wasn't able to do that with the screen sharing. I didn't want to screw anything up. So
thank you. Thanks, Jared. I see you. Thank you.
All right. Well, thank you very much. Thanks, Tim. This was awesome.
All right. See ya.
Thanks, Tim.
Thank you.
Bye.
Have a
Bye,
good
everybody. Have a great day.
Thank you.